Good afternoon. I'm Bill Brubaker. I'm the Dean of the University of Alabama School of Law, and it is my great honor and pleasure to welcome you to the Judge Frank M. Johnson, Jr. Memorial Endowed Lecture on Constitutional Rights and Liberties. We are honored to have with us today Martha Minow, who is the 300th anniversary professor and former dean of Harvard Law School. Professor Krotoszynski is going to provide a fuller introduction, Dean Minow, but I just want to take the chance to thank you for your generosity in being with us today. It's an honor to have you with us. You have made such a difference in the legal academy in the United States and, frankly, the broader academy. And we really do have the pleasure of having one of the foremost scholars in America with us today. So this is a great day for our law school. As many of you know, Judge Frank M. Johnson, Jr. was an alumnus of the law school, and he was one of the most significant judges of the 20th century. Dr. Martin Luther King, Jr. once called Frank Johnson the man who gave true meaning to the word justice. Judge Johnson always said he was just doing his job, but his courage and commitment to the rule of law make him a worthy subject of our attention and commemoration today. I want to thank my colleagues, Ron Krotoszynski, the John Stone Chairholder of Law, and Shalini Ray, the Yetta Samford Professor of Law, for their participation in today's program and their contributions to our law school more generally. After Dean Minow delivers her lecture, Professor Ray will offer a reflection, and then Dean Minow has graciously agreed to take questions for as long as time permits. So let me now call on Professor Krotoszynski to offer a brief history of the Johnson lecture and to introduce today's speaker. Thank you.
So, from Hollywood to Tuscaloosa, a brief explanation of why we are all here today. A single name explains, in part, the origins of the Frank M. Johnson, Jr. Memorial Lecture on Civil Rights and Constitutional Liberties. Wait for it, Martin Sheen. But before I get to Martin Sheen, let me quickly add that we all owe a great debt of gratitude to Director Ava DuVernay. Indeed, without her, we might not be here today. So what does a brilliant director, who also happens to be a woman of color, have to do with the FMJ Memorial Lecture? Quite a lot, actually, along with Martin Sheen. In 2014, she directed a wonderful historical film entitled Selma. The movie was about the SCLC's Selma Project. It stars David Oyelowo as the Reverend Dr. Martin Luther King, Jr., and co-stars Tim Roth as an appropriately villainous George C. Wallace. Who was Martin Sheen? If you haven't guessed already, Martin Sheen plays Judge Frank M. Johnson, Jr., and he reads aloud in the film critical parts of Judge Johnson's iconic, historically and legally important decision in Williams v. Wallace, commonly known as the Selma March case. In this decision, Judge Johnson granted an injunction that permitted the Selma to Montgomery March to proceed under the protection of the federal government. It went over 50 miles from Selma to Montgomery on US Highway 80 and ended with the SCLC's leadership, including Dr. King, attempting to deliver a petition asking the state of Alabama to recognize voting rights for all citizens without regard to race. Little George was actually in the Capitol peeking through the blinds. He did not meet, however, with those seeking to deliver the petition, but actually he did meet with Dr. King and a group of SCLC representatives about a week later. Didn't make much progress, but the meeting ultimately did occur. I have to detour a bit to note that this decision was strikingly bold, controversial, and in my view, incontrovertibly correct as a matter of First Amendment and equal protection law. The right to protest, Johnson thundered, must be commensurate with the wrongs being protested. In the case at bar, because the wrongs were, in his words, enormous and constituted blatant, long-standing, intentional violations of the most basic of all constitutional rights, the right to vote, the remedy had to be vigorous, meaning fully commensurate with those constitutional wrongs. The Selma to Montgomery March had a direct causal link to the passage of the Voting Rights Act later that year in 1965. The Voting Rights Act, of course, ended hair-and-vote democracy in the states of the former Confederacy, and for that matter, everywhere else in the United States where racial barriers to voting had existed. So what does this have to do with this lecture? Everything, actually. I saw Selma in Atlanta and was deeply moved. At the time, we had a listserv of former Frank Johnson law clerks. I wrote the group saying, hey, go see this movie. It's terrific. And Martin Sheen totally nails the judge. Although in fairness, I should add that Martin Sheen's Judge Johnson was the judge I clerked for in 1991, 1992, not the considerably younger man who heard and decided Williams v. Wallace in 1965. I should add I once had the temerity to ask the judge about that hearing and what it was like to have Martin Luther King as a witness. And he had these glasses and he paused and he said, very effective witness, highly credible. So that's a little Johnsoniana for you. It also happened that in 2015, the Alabama Law Review was hosting a major national symposium on the 50th anniversary of the Voting Rights Act of 1965. That was going to be the next semester, spring semester 2015, just over 10 years ago now. It struck me that this symposium would be of particular interest to Judge Johnson's extended law clerk family. I approached then Dean Mark Brandon and proposed inviting the law clerks to the symposium. He thought it was a great idea and agreed to support a reunion, our first meeting as a group since Mrs. Johnson's passing in 2013. The event was a great success, and we decided as a group that we should work to endow a lecture to celebrate Judge Johnson's jurisprudential legacy, as well as to promote the values, ideals, and principles his life and work embody, notably including an unyielding commitment to enforcing constitutional rights, respecting constitutional liberties, and securing the rule of law under the Constitution. In 2019, the law school and the Alabama Law Review hosted a major symposium on the centennial of Judge Johnson's birth on October 30, 2018, in January of 2019. Former Yale Law School Dean and U.S. Court of Appeals Judge Guido Calabresi delivered the first Frank M. Johnson lecture incident to this symposium as the keynote speaker. I also should mention that the law clerks have established and are also funding a memorial scholarship that honors both Judge Johnson and his beloved spouse and life partner, Mrs. Ruth Jenkins Johnson. Our crack development team would never forgive me should I fail to add as well at this juncture that donations to both the lecture fund and the scholarship fund are both welcome and essential to the continued success of both of these endeavors going forward. Got to get that in there, folks. It's a rule. So here we are, several years later, for the 25-26 Frank M. Johnson Jr. Memorial Lecture. It is now my distinct pleasure to introduce today's Frank M. Johnson Jr. Memorial Lecturer, former Dean and Professor of Law Martha Minow of the Harvard University Law School. Dean Minow currently serves as the 300th anniversary professor at Harvard Law School and teaches and writes about constitutional law and human rights more generally. Minow is a graduate, a proud graduate, go blue, of the University of Michigan, where she took her BA, the Harvard University Graduate School of Education, where she earned her master's, and the Yale Law School, where she obtained her JD and served as an articles editor on the Yale Law Journal. Following her graduation from Yale Law School, Dean Minow served as a law clerk to two truly iconic, indeed storied federal judges. First, with Judge David Bazelon of the U.S. Court of Appeals for the District of Columbia Circuit. Parenthetically, he's one of the most well-regarded jurists and theorists of the federal administrative state. And then for Justice Thurgood Marshall of the U.S. Supreme Court. Justice Marshall was, of course, a jurist famously committed to making the grand generalities of the Constitution and Bill of Rights meaningful lived realities, rather than just buzzwords and platitudes. He was also a lawyer's lawyer. He was the head litigator for the NAACP LDF Fund and later served as Solicitor General. It was Justice Marshall who designed and implemented a multi-decades-long effort to get Plessy versus Ferguson tossed on the ash heap of constitutional law history, finally achieved in Brown v. Board of Education in 1954. Professor Minow is a prolific and very highly regarded legal scholar. She is the author of 6 standalone books, and I learned last night she's busily at work on her 7th. Most recently, Saving the News, Why the Constitution Calls for Government Action to Preserve Freedom of Speech, Oxford University Press 2021, as many edited books, and literally dozens upon dozens of book chapters and law review articles and essays, most of which appear under the imprint of the world's leading university presses and in the pages of the nation's leading law reviews and law journals. In addition to her legal scholarship and leadership at Harvard Law School, Dean Minow has held many crucial leadership positions within distinguished NGOs, notably including the MacArthur Foundation, yes, the Genius Foundation, where she served as both a director and chair of the board of directors, a member of the Profiles in Courage Award Selection Committee associated with the JFK Memorial and Library, which she also has chaired, as chair of the board of WGBH and as a member of the board of WGBH. And if those letters aren't familiar to you, they should be. Perhaps they are if you watch a lot of PBS. GBH is one of the principal producers, nationally and internationally, of educational television programming. She's also served on the board of the Russell T. Grant Foundation, the board of the American Bar Foundation, and the Carnegie Corporation Board of Trustees. And this is merely a partial list of her service in the NGO space. Suffice it to say that Dean Minow has worked and is currently working with many of the leading educational, cultural, and philanthropic foundations in the United States. She has also undertaken significant and important public service work, including service on the board of directors of the Legal Services Corporation, commonly known as the LSC, one of the most important entities in the United States that provides direct legal services to the indigent. Indeed, she served as vice chair of the board of LSC and also as director of the organization. Other public service engagement includes service on the ABA's Diversity and Inclusion 360 Commission, co-organizer of the Law Professors Against Military Commissions Act, and service as a commissioner of the Independent International Commission on Kosovo, which was co-chaired by Richard Goldstone, a former member of the Constitutional Court of the Republic of South Africa. Her scholarly work and its impact have been recognized both nationally and internationally. These include Lifetime Achievement Awards from the Reporters Committee for Freedom of the Press in 2023. I should add parenthetically, this is one of the very most important U.S. press freedom advocacy organizations. The Ruth Bader Ginsburg Lifetime Achievement Award from the Women in Legal Education section of the American Association of Law Schools in 2024. The Joseph B. and Toby Gettler Prize from Brandeis University in 2026. And wait for it, 10 honorary degrees from universities located in 3 countries. These include honorary degrees from, wait for it, New York University, the University of Michigan, the University of Buenos Aires, Northwestern University, McGill University, the University of Toronto, and Hebrew College, among others. Suffice it to say that we are extraordinarily fortunate to have Dean Minow with us today as the FMJ lecturer. So, on behalf of myself, the faculty, staff, and administration of the University of Alabama School of Law, and the many former FMJ law clerks who are with us today, and without further ado, I happily and gladly yield the podium to former Dean and Professor of Law Martha Minow. We are so pleased that you are with us here today, and we look forward to your remarks as the 25-26 FMJ Memorial Lecturer. Let's give her a round of applause, please.
Thank you, Ron. You left out only one thing from my biography, which is I am not 300 years old. It is such an honor to be here. I give my thanks to Dean Brubaker, to Professor Kodanitsky, to the former clerks of Judge Johnson, and families and friends, and a special shout out to students. I'm so delighted that you're here. Now, undoubtedly, Judge Frank M. Johnson will be regarded in history as one of the dominant judicial figures of the civil rights era, a judge whose legal rulings have fundamentally altered opportunities for women and minorities in education, employment, voting, and other forms of socio-political expression. Those are not my words. That apt description is from attorney Brian Stevenson, founder and director of the Equal Justice Initiative, not far from here in Montgomery. And it underscores why this memorial lecture series matters so much. Judge Johnson's pioneering decisions brought light and light to prisons, mental institutions, and to criminal defendants, and therefore to the judiciary. Rightly a hero to lawyers across generations, Judge Johnson rejected blacks at the back of the bus, the law protested by Rosa Parks. He forbade the beating and harassment of freedom riders, seeking to end racial segregation in interstate bus travel. And as Ron just described, he enabled the historic march from Selma the Selma March that turned the nation's and indeed the world's attention to the problems here in this country, and absolutely directly led to the enactment of the Voting Rights Act of 1965, whose enforcement in turn changed this country, and whose enforcement right now is in serious jeopardy. Judge Johnson steadfastly and even-handedly enforced the law, and his words and actions bear a striking set of lessons for our moment. He made clear that respect for law requires action by judges who are themselves independent of politics, social pressure, peer attitudes, and intimidation. He also made clear that law and justice require commitments not just by judges, but also by lawyers and by other members of the community. He knew about challenges. He withstood death threats, social shunning. He brought steely determination, vision, courage, perspective to his courtroom. He never ducked hard issues. His personal qualities included strength, and I was hearing this morning even a little fear-inspiring behavior, but also humor. After one attorney frowned as a witness answered his question, the judge said to that lawyer, "If that look on your face constitutes an objection, it's overruled. If it's not an objection, then it is an argument to the jury, and I will deduct it from your time in closing argument." Another glimpse of his style. In the New Orleans courthouse, while several judges were waiting for an elevator and complaining about their heavy workload, Judge Johnson entered the elevator as it arrived, turned around and commented, "Well, it sure beats plowing." Now, just as I was graduating from law school, Judge Johnson explained, and I quote him, "Like good moral philosophy, good legal thinking is not discovery, it is emphasis." I think that's pretty darn good. And I'm sure that in our turbulent times, Judge Johnson would emphasize judicial independence, even-handed law enforcement, law aligned with moral commitments. He ran a tight ship, and even people who disagreed with the results that he announced respected him. His career etched into history a profound understanding that law should serve human beings, all human beings. And although I never had the honor of meeting him, I've studied his decisions and his role in American law. Closest I came to his beloved pastime of fishing is my last name. But I am so deeply moved by this opportunity to help honor this champion of justice, and I can't help but ask, what would Judge Johnson be thinking today? His insights and courage would be so welcome, because this is a time of danger in the United States, danger for the rule of law, for rights, for democracy. I turn today to civil rights issues raised by the digital revolution, and most notably by artificial intelligence. The vast range of activities that are enabled by computers, large data sets, tools to recognize patterns. We all have it in our phone, whether we like it or not. Make classifications, generate predictions, to learn to generate language and images to perform complex tasks. I'm going to call that AI, but there are other definitions of AI. The International Organization for Economic Cooperation and Development defines AI systems as a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate output such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. And I will use the term in a similar way and focus on decision systems, decision-related systems that potentially have discriminatory results. Artificial intelligence tools now affect employment, consumer advertising, consumer purchasing, healthcare, housing, banking, education, immigration enforcement, defense systems, and my washing machine, last I looked. The US government is a big customer of large AI platforms, including Palantir's comprehensive immigration systems, Clearview AI's face recognition tools, B12's iris scanning devices, and Paragon's phone hacking software. that the government of the United States now uses to connect and analyze data about people. In these and many other instances, AI presents the emerging frontier in the struggle for human rights. It is no longer the domain of science fiction to consider replacing human work and subordination of some or all humans to technical artificial systems. And whether this is a revolution or an evolution, it is never going to leave American or the world the same. The speed, range, and surprisingly quick improvements in AI. You saw its results on the bar exam in 1 year, went from not so good to like acing it. It is rather extraordinary. And the effects on drug discovery, mapping the ocean floor, there are some fabulous uses of AI that we should celebrate, but I'm not going to do that today. Instead, I'm going to identify potential civil rights concerns. Invasions of privacy, longer-term suppression of speech and assembly, spread of disinformation, jeopardy to democracy are only some of the consequences of the uses of AI. Another time, another place, we could discuss the displacement of workers, the impact on the environment, the consumption of energy. That's for you to do. Inspired by the clarity and devotion of Judge Johnson, I want to focus on human equality. And this age of AI requires conceptual work and really hard practical work to defend and advance civil rights. It's going to change all of our lives, and I know that you all will have a role to play in how the world responds. So let's map the challenges. Automatic systems and AI tools bring efficiencies, but also errors. AI tools are used, as I've said, in employment, also housing, education, financial services, retail sales, criminal law, and the risks of harm to individuals and communities are genuine, from data mining, aggregation, pattern recognition, prediction, and in times mindless application by human beings of whatever the AI comes up with. AI systems work at a scale and speed that is really unprecedented. Algorithmic automation and AI tools produce decisions that are invisible, opaque, lacking explanations that human beings understand, and by that I mean even the people who design the systems. AI-generated analyses can carry the appearance of scientific expertise and objectivity and summon deference by human beings. Let's look at employment, just for starters. Employers can and do use AI tools to screen job applicants, to interview the applicants, to guide hiring, promotion, firing decisions. How many of you have already encountered that? Have you had AI involved? I'm sure you have, and some of you haven't raised your hands. You have too. AI may be built in by a company, or it's licensed by vendors, and the employers use AI tools to analyze social media usage and to evaluate prospective employees. And often that means having access to information about the individual's race, sex, age, disability, political views, and other protected characteristics in ways that federal and state law ostensibly say are illegal. Actual enforcement of those laws and knowledge of the violations are just some of the obstacles. Secrecy, opaqueness of the practices is another major obstacle. When AI filters resumes from job applicants, it can give preference to candidates who are similar to those who were hired in the past. What does that do? That entrenches what the patterns were in the past. What were those patterns in the past? Well, I can tell you they weren't historically inclusive and reflecting America. This seems to be why Amazon's AI tools for screening resumes rated men higher than women in analyzing software jobs. And AI tools examine video interviews, which can disfavor people based on facial expression, appearance, accent. HireVue is a provider of such a service to many companies, and it did stop after the federal government filed a complaint after use of its facial analysis, but the company has continued using intonation and behavior detected by its analyses of video screening, and yes, it sells those services to employers. In one case that is still pending in court right now, a disappointed job applicant sued Sirius XM Radio and alleged that reliance on historical hiring data used by the employer amounted to both intentional and unintentional discrimination by the AI system because the practice perpetuated past biases. Predicting who will succeed in a particular workplace, the AI tools often favor people from particular zip codes or educational institutions, again, replicating past patterns. The company Meta settled a suit charging illegal discrimination when its machine learning tool disproportionately directed ads to white users for housing in a majority black zip code area. And a tutoring service settled a suit brought by the Federal Equal Employment Opportunity Commission against an employer who used a software hiring program that automatically rejected any female applicant aged 55 or older and any male applicant 60 years old or older. When multiple employers use the same tools, certain applicants can be systemically excluded across industries, across all of their job applications. And researchers are identifying how the testing methods that are used by the AI developers can lead to biased outcomes, even when they're trying to improve the tools. Generative AI can allow automated applications on behalf of individual applicants for jobs that match their resumes, but introduce risks of error and bias, and generate materials that actually are not valid. Many people will not even see the ads for certain jobs because the recruitment ads are distributed based on algorithms that are trained on limited sets of data, on assumptions based on gender and age, disability, etc. Algorithmic systems do not correct gaps or distortions with contextual knowledge the way that human beings do. AI may not correct for skewed patterns from data sampling or omitted variables. LinkedIn found gender bias in its recommendation algorithms used to connect job candidates with opportunities, even though gender was not a factor in its directions. The algorithm relied partly by predicting on who was likely to apply, which probably actually encoded certain characteristics about aggressiveness, which probably had a gender link. Similar problems come with AI uses in housing, reflecting and amplifying different patterns by race and wealth. Those patterns are very stark. 74% of white Americans own their homes, only 46% of black Americans do, and that difference, that gap, is much wider today than it was in 1960. The initial challenge to racial bias in housing ads came in a suit actually that was brought by the Department of Justice under the first Trump administration. And a machine learning tool built by Meta disproportionately delivers ads, housing ads to white users. Meta settled, promised to use another tool, also started using AI to try to check on bias. Now, during his second term as president, Donald Trump has a different attitude. In his commitment to undo diversity, equity, and inclusion measures, the Department of Justice and indeed the entire federal government has rescinded priorities related to civil rights. It has rescinded any program and punished entities that have programs identified as diversity, equity, and inclusion. It has altered and ended regulations, investigations, property appraisals, funding that Republican and Democratic administrations have used for 45 to 50 years to try to combat discrimination. That's across the society. Selective education institutions may, as part of their admissions processes, yet another sector using AI, use AI to investigate social media posts and analyze them, to look at family wealth, family voting records, consumer purchases, and the race of the individual applicant. In one study showed that AI tools rate applicant essays in ways that reflect the socioeconomic backgrounds of the individuals who wrote them. A United Nations report identifies how predictive analytic tools help educators improve student outcomes, but often rate the members of racial minorities as less likely to achieve academic success. And the advisors who use those tools, of course, steer people accordingly. Some colleges and universities turn to AI to detect AI use by students in their essays. And the story is not all against AI because the use of free AI tools' availability to generate and edit essays at least levels the playing field, comparing people who can pay for someone to tutor them or help them with their essays as opposed to people who can't afford to do that. But now what? It's AI admissions officers reading AI essays? No comment. Financial credit's one more field. And you can imagine the story's going to be very similar, but here's an example that troubled me. An immigrant who lacks an American credit history, someone who shops at night, those are the kinds of individuals that will be pulled out from AI pattern recognition as not worthy of credit. I think a human decision maker might approach those matters differently. When Apple offered credit cards, a man named David Heinemeier Hansoon received offers of 20 times the credit rating that his wife received, even though her commercial credit score was much higher. He objected, and yet gender-based distinctions appear in the use of credit rating across the industry. The U.S. Consumer Finance Protection Bureau fined Apple for violating its public transparency rules, but the company overcame the charge of discrimination by showing that its algorithm relied on credit scores and indebtedness and income, in other words, objective characteristics, not gender. Why does AI do this? Because it is engaged in pattern recognition. It can see what the patterns are in the past, and the patterns, guess what? Reflect biases of the past. Algorithms intended to detect fraud or help consumers avoid bank overdrafts similarly have produced high levels of error. A district court in the Netherlands found a welfare and tax fraud system violated its rules about transparency and explainability and protections against bias and did not detect one single instance of fraud. The U.S. Consumer Finance Protection Bureau sanctioned deceptive practices of a company called Hello Digit, a finance company, because the company wrongly claimed that its tool would prevent checking account overdrafts, but it did the opposite. It punished the people's people with the checking accounts. The turbocharging of goods sales and services sales by AI online, we all experience. Whether we want to or not. Sellers of goods and services target not only ads, but also the pricing of goods and services based on what they can find out about each of us. When a friend and I at the same time call for Lyft or Uber, we get different estimates about how long to wait and how much the ride will charge. And why is that? Well, I can tell you, the algorithms are scanning all of our data and the much that the companies can have access to. Many companies deploy personal information to do this kind of surveillance pricing, surge pricing. And if it's based on supply and demand, I have no problem with it. But a lot of people have problems finding out that it's personalized based on, being able to see your past purchases. Instacart, the retail and delivery company, found that its pricing algorithm could lead one household to spend $1,200 more on groceries over the course of a year than another similar household, and they couldn't explain it. The targeting of ads affects people differently if they don't use the internet much, or if they do. It's also exposed a divide between those people who are savvy enough to use digital tools like a virtual private network or an alternative browser to try to avoid the surveillance. Meantime, companies using the same tools or tools to mirror the moves of other companies, yes, that is happening. Guess what? They are engaging in collusion that the antitrust laws say they shouldn't be doing, but it's happening right now. Criticisms of AI, of course, have to be compared with criticisms of what happens in a world without them. It's not like discrimination doesn't happen with human actors. It does. And in some instances, AI may actually help to reduce the risks of bias by humans. But left alone, private companies are not likely to resist the draw of making more money. And if there is no regulation, the patterns that I'm describing will not only continue, they will escalate, they will amplify. President Trump rescinded a Biden-era regulatory effort to protect consumers in the name of promoting innovation. He closed the work of the Consumer Financial Protection Bureau that had been a key actor in trying to deal with these issues. The administration also proposes to override any state law that calls for disclosure and explanations of AI, and the AI use by government actors is itself increasing. I mentioned Palantir and the other companies, but do you know that actually the use of AI in the criminal system is widespread, or machine algorithms somewhat less sophisticated? And this leads to making predictions about who's likely to show up in court after an arrest, or who deserves probation, or what kind of sentence people should have based on characteristics like what is their likelihood of rearrest. Well, let me tell you how the likelihood of rearrest is calculated. It's based on where police are. Who decides where the police are? Guess what? It's a predictive algorithm that assigns where police will go. My hometown of Chicago is a key actor in doing this. So your likelihood of being arrested is a function of where the police think crime is going to happen, and that will determine whether or not you can get bail. State and federal laws that predated AI can be used to combat some of these activities. I think they're inadequate, and that's what I'm going to turn to now. Existing legal frameworks are just not up to the task. Spoiler alert. Whether in the US or elsewhere, and AI uses can perpetuate and even enlarge discrimination and unfairness while baffling the tools of law. The Equal Protection Clause of the United States Constitution provides for potential liability where government actors discriminate on the basis of race or gender. Federal statutes support claims not only against government but also against private actors if they intentionally discriminate based on race or gender or age or disability. And statutes and regulations provide liability beyond intentional discrimination for what we call disparate impact. Disparate impact provisions in the US, state laws apply to private companies, not just to government. And that includes also companies that are contracted by the government to perform tasks. And these seem like pretty good framework, but none of them are adequate in dealing with AI. Let's start with the Equal Protection Clause, which has a requirement of demonstrating intentional discrimination on the part of the defendant. Courts have concluded that this intent requirement is mandated. They did so in 1976. And plaintiffs, therefore, need to show that the defendant, a government actor, explicitly, intentionally used the classification, for example, of race or color or national origin. Guess what? That's hard to do. Really, really hard to show. What are you going to find? Someone's email, they say, we mean to discriminate? Really hard. The Supreme Court has suggested that courts can infer impermissible intention, for example, from some circumstantial evidence like suspicious timing of a decision. But there still is a requirement of linking up that circumstantial evidence to purposive discrimination. Similar requirements apply to the intent-based liability claims authorized by statutes, for example, in employment and housing. And none of these do well in responding to AI. The intention that matters, let's start with it, is by human beings, not technology. The task of showing intention when there are multiple people behind the creation of AI is a problem. Negligent or implicit bias is not enough to show intention. And the notoriously opaque dimensions of AI make proving anything about what went into it very difficult. And I'll say a word about each of these. The human intention that is required to show intentional discrimination, that's what the law has said up until now. It hasn't really been asked to consider other kinds of intention. There are philosophers now debating, and lawyers too, whether or not AI has a mind. Is it a person? Let me tell you, nobody knows the answer. There isn't actually an answer right now, and certainly it has not been sufficient to establish intent under the Equal Protection Clause. One professor has proposed that the decision-making by a computer based on past human decisions should be treated the same as human decision-making. Nice idea, no court has bought it yet. Second problem, not just requiring human intention, the fact that all AI systems involve many, many people behind them makes it really hard to show intention. This is the many hands problem. Many people are involved in designing an AI model, in revising it, in deploying it, in developing the apps on top of it, in reconfiguring it, in tuning it. How do you show intention connecting all of those people? Detecting illicit discriminatory intent is notoriously difficult when you have a group defendant. And here, the groups can be literally thousands and thousands of people. AI, increasingly, is one of those people, if I can say it that way, because you have AI agents that are participating with the other actors. And so it compounds the problem. Is it AI intention that is bringing the discrimination to bear? And what about code that is being written by AI, as it is all over the country right now? Perhaps we will see some legal decision in the future assigning responsibility to the human beings involved who ought to be supervising in some way. Meanwhile, human efforts to overcome bias in AI systems could itself trigger the laws against intentional discrimination. If they use conscious attention to race, for example, to try to counter racist effects. Kind of ironic. Third problem, human intention that matters is conscious and deliberate. It's not implicit bias, it's not unconscious bias, even though social scientists demonstrate to us how pervasive implicit bias is, how pervasive unconscious bias is. That does not satisfy the requirement of purpose. Fourth point, very related, negligence is not enough. Even when individual developers construct their code to select data sets for training, if they are not paying attention to try to guard against bias, that's not going to amount to the required purposive, intentional discrimination. Proving actual intent to enact discrimination is difficult, if not impossible. And when the AI looks at patterns, like historical patterns, and the humans say, yeah, go ahead and do that, that can be defended in a lawsuit as negligent, not intentional discrimination. And finally, AI is not transparent. It's notoriously called a black box. Even its developers can't explain what's going on. The development of something called explainable AI is kind of hilarious because I recently read a report where a lot of experts can't understand the explanations that are offered that are as explainable AI. And when there are explanations or something that's called steps of reasoning AI, there's no evidence that actually that is a window onto how the AI works. It's most likely that that's actually just sampling and then predicting based on discussions about what humans like to hear are reasons or explanations. It is not at all clear that it's a window onto what's really going on. Dario Amodei, who's the head of Anthropic, a leading AI company, recently said, people outside the field are often surprised and alarmed to learn that we do not understand how our AI creations work. They are right to be concerned. This lack of understanding is essentially unprecedented in the history of technology. This is one of the leaders in the field. Efforts to devise explanations are not enough. The opacity, the opaqueness makes litigation, enforcement, just about impossible. And just to make our skins crawl a little bit more, there's now evidence that AI systems can detect when they're being watched and change their behavior. So when the AI system knows that it's being evaluated, it may, for example, during that time say, okay, we will veil our use of historical data. And then when it's not being watched, go back to it. So 5 big problems. And the anti-discrimination claims, at least under intent, are not going to be able to solve them. And I do want to note that there are efforts to bring lawsuits, and maybe some of them will succeed. There's one pending right now against a company called Workday that has AI features in something called Hired Score that allows and that works as an agent of employers. And a court recently allowed an effort to have a class action suit against this particular company to proceed. And the named plaintiff is a man named Derek Mobley, an African-American man who's over 40 years old. He received rejections within hours and sometimes within minutes of submitting his applications for jobs. He received over 100 rejections, and then he brought this lawsuit. And maybe this will continue, but it's also likely that the company will seek to decertify the class as being too diverse and not unified. And maybe this case will be modified to pursue the second avenue of anti-discrimination claims, disparate impact, and I'll turn to that now. But there are some real barriers to disparate impact claims as well. This is the alternative. Don't have to show intent, do have to show that there is a disparate, statistically notable difference in the consequences of even ostensibly neutral practice with regard to a protected trait like race or gender or age or disability. And there are many laws in this country, state laws, as also laws in Australia and the European Union and Canada, Singapore, Taiwan that use disparate impact as a method to demonstrate discrimination. Such laws actually create a multiple step process. The plaintiff can challenge, for example, the use of a written test for employment by showing that there are different patterns of test scores based on different groups of people, like racial differences. And on doing so, then the evidentiary burden shifts to the defendant. The defendant has a chance to rebut it, to say, well, I had to do it, or it serves this other objective purpose. And the plaintiff will then have some difficulties being able to succeed in this claim. But those aren't the only difficulties. The difficulties include, again, the opaqueness of the AI, how to get the relevant data, how to show how AI is actually operating. And you know, when you run AI, you won't get the same results the second time. It's not replicable. This is a major problem. The defense that the companies may offer to using their AI systems is business necessity. And business necessity is a big, capacious category, flexible, and allows a pretty easy way for companies to say, well, we're doing this for business reasons, it's cheaper than other activities. That will be enough. The future of disparate impact theory is even more in doubt in the United States right now. President Trump directed federal agencies to eliminate its use in all contexts to the maximum degree possible. That was one of his executive orders this year, or last year. The administration rescinded disparate impact as a basis for bringing lawsuits or enforcing regulations by the Department of Justice, the Department of Housing. I can go on and on and on. The disparate impact theory can no longer establish illegal discrimination in the administration of funds that are allocated by the federal government. And meantime, Supreme Court justices have cast their own doubts on disparate impact theory. And they've even suggested that Congress and administrative agencies do not have the authority to use disparate impact, and doing so, at least according to one justice, violates the Equal Protection Clause. Now, European laws, state laws may continue to use disparate impact. This larger context in the United States of backlash against affirmative action, judicial rejection of voting rights enforcement, a particular president who opposes diversity, equity, inclusion, it all makes disparate impact analysis in this country quite uncertain. And so I think this is a moment for creativity and imagination. One existing theory that it's seldom discussed, I put it out for you to think about, is the class of one discrimination. The United States courts have recognized it in 2 cases so far under the Equal Protection Clause. And this theory permits actions by individuals who are not a member of a protected group. So it might be relevant to that kind of dynamic pricing where I and my colleague get different prices quoted by Lyft. The class of one theory basically says that if there's irrationality, there's not an ability to explain why this person is being treated differently, it violates the Constitution. The Supreme Court endorsed this theory in a case called Village of Willowbrook versus Olek. And in that case, Grace Olek and her husband were trying to connect their property to the municipal water supply provided by the village. But the village would permit the connection only if the couple would give an easement of 33 feet across their property. And they hadn't required that of anybody else. The Olek sued. The village backed off, provided the water service with a usual 15-foot easement. And the Supreme Court of the United States, in the case that the Oleks had already filed, said there was a valid claim to objecting to this government action. I think that this class of one idea, at least conceptually, is pretty interesting as a way of challenging irrational results. It would require some invention and some expansion to be used in the AI context, but so will everything else. And I will identify a few other areas where maybe some imagination could be used to develop new responses. One is new laws, and the cutting edge right now is states. The states are the action in the United States, certainly not the federal government. California prohibits the sale of geolocational data. And it's also made clear that its existing anti-discrimination laws, as in housing and employment, apply to AI tools. Colorado, Illinois, New York, they've all adopted laws that mandate employers to give notice of their use of AI in hiring and face independent bias audits. It's a step. It's not banning these activities, but it's a step. And the California reforms don't reach the use of tools that replicate past patterns. That would be something to try to explore by law. There are also common law and statutory treatments of consumer protection, employment, privacy, and there are people bringing lawsuits. And starting in June of this year, Colorado's consumer protection law actually specifically provides that artificial intelligence systems identified as high risk have to be accompanied with reasonable care to protect consumers from known or reasonably foreseeable risks of discrimination. That seems to me real progress, to start talk about reasonably foreseeable risk. The European Union's AI Act does seem to appear to impose more stringent requirements. Of course, it prompted criticism by President Vance in this country, who said you're setting back development, and the European Union seems to have slowed down its enforcement. But it is fascinating to me to see how they have gone so far as to ban the sale or use of tools that deploy subliminal, manipulative, or deceptive techniques with the goal or effect of impairing informed decision-making by individuals. And it's also prohibited predictive profiling in law enforcement. It's prohibited emotion recognition in sensitive settings, and it's prohibited biometric categorization. Those seem to be areas to watch and something that some states here could copy. Another area that might be a source for some creativity is ideas about fairness that are developed by academics. Sorry, I'm an academic. But consumer scientists have been debating for about 20 years now. What is fairness and how can they actually advance fairness in their work? There are technical definitions and disagreements, but it's a source of insight that could be tapped for law. And beyond computer science, there are lots of people who are exploring that dreaded word equity rather than equality and looking at results and the particularities of individuals, not reducible to any one characteristic. You know, for example, the Education for Individuals with Disability Act, the IDEA, calls for individualized assessment of students for disability accommodation. That's one way to try to take the insights about anti-discrimination and acknowledge the varieties of human beings. I think that we need to broaden our imagination. We need to canvass new ideas. And here I am really affected by a lecture I heard once by the inventor of Sims. Anybody ever play Sims? Okay. So Will Wright found that the concentration of video games in first-person shooters was so narrow. He said there's so much more we could be doing. So he invented Sims, SimCity. You can use these tools to create a whole environment. He then created a game, some of you may know, called Spore. Spore, you start with one celled organism and you can build all of evolution from it. His idea is, don't just all huddle in the corner with first-person shooter games. Let's use this possibility, this canvas, to explore many more opportunities. And I think that that's a message for lawyers right now. We have to be imaginative. We can't just recycle what we've done in the past because it's just not adequate. Dare I say, AI itself may be a resource for regulation, and we should explore that. So I'm going to close by acknowledging that we're surrounded by government and private actions that do or have the risk of depriving individuals of fairness in person and online, of equal treatment in person and online. And true justice requires the attention to both government and private sector actors. Centuries of law offer lessons about the value of procedure. Procedural fairness is another source that we can look to. These lessons deserve application and testing to pursue transparency in AI, accountability by the people who are making money off of it, opportunities to challenge its effects, strengthening the forums for debating and developing and refining new legal and community responses. I come back to Judge Frank Johnson, who showed the way to act with clarity, conviction, and courage on behalf of civil rights and equal treatment under the law. Indeed, he showed a way to put human dignity at the center. His biographer found in the judge's files a written plea of a prison inmate and showed how it captured the essence of Judge Johnson's role in Alabama's human rights revolution. Those are the words of biographer Kingsley Yarborough. The inmate's note, here's what it said: "I guess you're tired of hearing from us, but you're the only one who seems to want to help." The work of helping now is up to us. Thank you.
All right, well, thank you all. Thank you to the organizers of today's lecture for this opportunity to share reflections on Dean Minow's remarks in honor of Judge Frank M. Johnson, Jr., an inspiring figure of the civil rights era and one of our alums, I learned. So in the spirit of enlarging the canvas of ideas for responding to the challenges that Dean Minow outlined, as she invited us to do, I want to draw our attention to the civil rights and civil liberties implications of the use of AI beyond the distribution of jobs, housing, education, and financial services, the traditional province of anti-discrimination law. And I'd like us to consider AI in the realm of enforcement, administrative enforcement. With AI technologies supercharging government data collection and surveillance capabilities, the government can detect suspected violations of the law in far greater numbers than before, fueling the possibility of much fuller enforcement in a variety of domains. I offer a few observations about why a regime of total data exposure is normatively troubling, and how we might respond by using the example of immigration enforcement. At some level, very basic level, immigration enforcement exists to give effect to the statutes that Congress has enacted, regulating non-citizens' entry into and removal from the United States. The foundational statute of U.S. immigration law, the Immigration and Nationality Act, authorizes deportation as the sanction, or designates deportation as the sanction for a wide range of immigration law violations. For example, committing certain kinds of crimes can make someone deportable, of course, something we all know, but so can overstaying your visa, not updating your address in time, a host of lesser offenses. So these are all, technically speaking, deportable offenses and violations of civil immigration law. So what are the implications of the government increasingly relying on AI and enforcing this regime? First, I'd say people engage in lots of ordinary and even socially useful behaviors that generate data through records, filings, registrations. And when the government leverages these records for immigration enforcement purposes, it very well may discourage these socially useful behaviors that produce these records. So for example, I think the IRS recently admitted to sharing taxpayer information with the Department of Homeland Security for immigration enforcement purposes. So workers going forward may not be filing taxes to the same extent as a result of that. Families might hesitate to register children for school, or neighbors might decline to report crimes that they observe or know about if those reports could trigger immigration enforcement action. More recently, the federal government announced, I think actually just today or maybe a couple days ago, that it's considering drafting banks into the cause by requiring them to, I think, monitor and screen the citizenship status of account holders. So the potential chilling effect on useful behaviors stands to potentially reduce our collective well-being, and I think is one consequence of what we're seeing. Second, recent developments have magnified the potential for race discrimination in immigration enforcement using AI tools. So some of you may have heard of the shadow docket case called Vasquez-Perdomo. Or maybe not, maybe that's a little too niche, but in that case, the Supreme Court essentially in this shadow docket decision sort of gave the green light, people are saying, to immigration enforcement officials using a variety of characteristics like language, race, including race, location, I think the type of work someone's doing, to support a reasonable suspicion that the person might be a deportable non-citizen, all right, someone potentially subject to enforcement. And what was sort of new about that decision is the express blessing of considering race. Usually, at least in the interior, that was not allowed. And so what does this have to do with AI? Well, when you have vast, troves of data that can filter people's faces and instantly sort, you can have that initial encounter that is based in part, let's say, on race or language, and then immediately, officers can sort of figure out, is this someone who we would, want to further pursue? But that initial detention, that initial arrest, is sort of fueled. This regime is fueled by the fact that they can use AI to kind of quickly, in an ideal world, quickly make decisions. But what we found is that it's not so quick for many people. I think over 170, I saw a news article, 170 US citizens have been detained in this kind of operation. And so obviously there are still errors. Okay. And then finally, government has used AI facial recognition technology to distinguish citizens from non-citizens, which has led to what looks like the punishment of citizens and non-citizens alike for engaging in potentially constitutionally protected conduct, like in some instances, peaceful protests. So for example, a citizen in Minneapolis reported being photographed at a protest and then later summarily losing the privilege of global entry without explanation. All right, so maybe we aren't so moved by the loss of global entry, but there are citizens who've asserted more serious rights violations as well, being photographed while engaged in a peaceful protest and then being cataloged in a database which may be marked for domestic terrorists. Such a classification and the really super detailed tracking of people has a host of consequences, such as subjecting people to routine secondary screening when traveling. Red flags can come up in routine background checks when people apply for jobs, which actually brings the discussion back to sort of the traditional subjects of anti-discrimination law, such as the distribution of jobs. So I'll offer a couple of preliminary thoughts for responding to these developments. So first, many have observed in the current age, we need data collection and data use safeguards, not just norms, public opinion, or market signals. So, concrete example, there's a federal statute called the Privacy Act, which governs information sharing between federal agencies, but it currently contains a very significant exception for law enforcement. Congress could potentially narrow that exception so that data, the type of data transfers that I was describing, may not actually be allowed. This reform is particularly worth considering given that immigration enforcement is actually civil. I think a lot of people assume it's part of the criminal legal system because often there's a nexus, or something in the criminal legal system leads someone to be put on the immigration radar, but it's a civil law system, and the constitutional safeguards are accordingly much fewer for people who are targeted for removal. We should also think, and this isn't really AI specific, but I think given the kind of pace and volume of potential rights violations, we should think about pathways for creating accountability. So there's been some talk, I've heard a lot of talk about the creation of a federal counterpart to Section 1983, which I first learned about in Professor Minow's class. And representatives such as Jamie Raskin have already proposed legislation, I think, to achieve this. This would allow victims to sue federal officers for unconstitutional conduct, sort of like in the Bivens action that some of you may have learned about, that was once thought to serve that sort of purpose, but which has been narrowed substantially by the court over the years. And then finally, to curb violations of civil rights and civil liberties in immigration enforcement, I think we should recenter the role of prosecutorial discretion in immigration law and abandon a regime of arrest quotas and bounties that reward wrongful arrest and detention. AI has the effect, I think the most important sort of point about AI here is it has the effect, how I see it, as a flattening the pool of targets for enforcement. It's basically anyone who's salient, to the government is fair game. And that could be through engaging in behaviors that are actually good, like complying with a court date or going, for an interview when or going for a check-in, right? All these sorts of things that you're supposed to be doing can make someone salient to the government. And same with behaviors that generate data that I mentioned earlier. And so this flattening, I think, of sort of all targets are equally, worthwhile, I think is out of step with our law. Our immigration law is built around the idea of extending membership based on family ties, economic contribution, and shared values. And someone who has lived here, I think, for decades without incident, who has citizen children, grandchildren, pays taxes, is deeply rooted, is simply not the same as a recent entrant who has no ties. As a formal matter, the INA makes them sort of equally susceptible to deportation under our immigration law. But the statute, when read as a whole, I think suggests that ties matter quite a bit. Congress has specifically tasked the DHS Secretary with setting enforcement priorities, which further suggests that high-level executive officials are supposed to be making judgment calls about how to deploy enforcement efforts. So I would argue that our basic immigration law supports the view that not all removals are equal, and to the extent deporting an individual produces a public benefit, if it's supposed to be in the public interest, it's important to recognize that some do the opposite. Some would undermine the public interest. They can destroy family unity, eliminate valuable economic contributions, diminish community safety and solidarity. But the reliance on the types of technologies that have been discussed today makes really anyone with a data trail salient to enforcement officials and can lead actually to the perverse prioritization of people who are doing the right thing and who are on the government's radar for that reason. So I would just reiterate, I think the regime of bounties and quotas pushes line-level officers to pursue targets, view them as interchangeable, and to have the view that differences simply don't matter at all. So when addressing the fallout of AI-fueled enforcement, I think the structure of enforcement discretion matters more than ever. Ultimately, this is an opportunity to think about what law execution can and should mean in the age of AI. There's a lot of talk of having a muscular executive, and that might mean someone who aggressively delegates and makes very few calls on their own. That is a vision, I think, of that. But on another view, the executive is responsible for offering a policy vision and making informed, thoughtful judgment calls. On this view, one could believe that on this latter view, that an AI-fueled mass deportation campaign has the potential to diminish the role of the executive. Instead of drawing meaningful distinctions across a vast population of potential targets, the executive is largely driven by the outputs of algorithmic technology. And I would argue that's not an appealing vision of faithful execution. So if we surrender, the future to a future of perfect surveillance, it'll be safe to say that the robots will have won. So, thank you.
Well, thank you, Dean Minow. Thank you, Professor Ray. I must say that I thought about Judge Johnson, who was known for applying fairness and justice to fundamental questions facing American life. And I think your lecture certainly follows well in that tradition, and we're again so grateful. If I may, I want to be respectful of folks' time, but perhaps we could take a couple of questions here. Would you mind doing that? So again, thank you so much.
Well, thanks for the kind words, and Professor Ray's comments, I think, were so insightful and striking. The last suggestion about prosecutorial discretion, I really endorse, and maybe the world that we are building could be one where human bias is checked by AI, but AI has to be checked by humans, so some kind of hybrid may be where we're going, where we should go. I wrote a book a couple years ago called When Should Law Forgive that examines the critical role of forgiveness inside the legal system, including prosecutorial discretion, police deciding not to arrest this particular individual. This has been built up over centuries, the recognition that actually human welfare is improved by this kind of don't enforce the law 100% because there are multiple factors. One thing AI is terrible at is reconciling competing demands, competing factors. That's one thing humans are really good at. That's something that we teach at law school. And that retention of the human qualities, I think, is just at the core of what you said, is absolutely essential. Another thought about your comment, and then I really do want to hear questions. I couldn't help but think, not everybody cares about immigration law. I'm so glad that you do. But if you're a citizen and you don't care about it, this is the time to care about it. Because actually the quotas and the practices you're describing make no distinction, really, between citizens and non-citizens. And I can't help but remember, I don't know how many of you have encountered the words of a man named Martin Niemöller. He lived in Germany at the time that the Nazis were taking power, and he actually was a supporter of the Nazis until they started to be critical of churches, and he was a minister, and he was actually arrested. And it was at that time that he made a statement that's now become quite famous, and I can't help but read it right now. It's a poem, and what he said, if I can find it again, first they came for communists, but I did not speak out because I was not a communist. Then they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak out for me. And I do think that the joining together of authoritarian practices and AI will be precisely, they came for all of us. So not to put a downer on the discussion, but who has a comment or a question? Or advice?
I was intrigued by the problem of monitoring and the black box problem.
Yep.
And I'm working on a book with some Europeans on
Digital Services Act, yeah.
And yet the enforcement mechanism, which you adverted to, trust these companies, which you posited are primarily driven by profit motive and shareholder return, to address systemic risk, which include many of the things you talked about. How do we come up with a regulatory regime that works? Because the DSA and the GDPR look really good.
Right.
But my European colleagues say that the enforcement is deeply problematic because it relies on self-policing and there's no incentive for effective self-policing.
It's a major problem. Even if we go back a generation, like 10 years on regulation, social media similarly relies on the self-regulation of the platform companies, and that has not actually worked very well. I think that two thoughts. One, and the Europeans actually have pioneered this too, there can be the development of strict liability rules that require the internalization of the costs. And the burden is on the platform companies to show that they have actually taken every step necessary. That's because government will never have the resources, time, money, expertise to do the enforcement. But you can, by law, put the burden on the party that has the knowledge and has the resources. So that's one thought. Another thought is that actually when it comes to the issues of data retention, data protection, if there is a distribution out to the end user of the right to sue, which is what the Europeans have done, that actually can put a fear into the hearts of the General Counsel's office that's advising the companies. So I think that kind of direct enforcement possibility is important. One more thing I just want to say is that lawyers have spent literally centuries dealing with the problems of human mistakes. AI makes mistakes. And the current regulations bypass all of the legal rules that we've developed to deal with mistakes. Did you know that there are experiments now with smart contracts? So when there's a breach of contract, it automatically takes money from the bank account of the breacher, bypassing all of the defenses, all of the techniques of contract law. I think that actually the European Union will be more courageous than the US in saying, no, we want to have what they call in the environmental area the prudential principle, which is we won't allow the technology to be let out in the wild until it's shown to be safe. So that's another switching the burden, and the Europeans do that, we do not. Thank you.
How do you see competition with non-Western based AI companies affecting the way that the U.S. develops policy?
Such a huge question. I actually taught a class last year on comparative AI regulation, and I will largely be drawing on what I learned there. There really is a competition about how to do AI and how to regulate it. There are countries, China most notably among them, that entwine the government inside the companies. That's a very different model. The US's approach has for a long time been largely rely on markets. Now it's 100% rely on markets, at least in the federal government. European is much more this prudential approach, show us that it's not dangerous. One of the dangers, and we see this with TikTok, is that you have companies that are based in one country, but they are global. And so what law applies? Well, again, the General Counsel's office seems to me worth thinking about. General Counsel's office is going to be looking at all of the laws that apply, and that's a reason for everyone to pay attention to international law and comparative law, but also, yes, to imagine that even if there's deregulatory or non-regulatory countries, other countries will be regulating, and that will matter. And I should say, back to Ron's question, I took corporate law. I can't say I paid much attention. I really wish I had paid more attention, because I now think that the audit committees of publicly traded companies are the audience for all of the things that we're talking about. The issue of the risk of regulation in another country, for example, but also the liabilities of unknown lawsuits. The audit company is the place to go, so take corporate laws, turns out important.
Well, thank you again for a wonderful afternoon, and again for being with us. And so we are adjourned. Thank you.